What happens to a country when it starts to question who truly belongs? Today, America is not just debating immigration policy, it is debating the very meaning of citizenship itself. The Supreme Court's decision to hear the challenge to birthright citizenship, a principle anchored in the 14th Amendment for more than 150 years, is far more than a routine legal dispute. It is a stress test of the American constitutional system, of presidential power, and of the country's identity in the 21st century. At the center is a simple but explosive question. Can one administration narrow a fundamental right that has defined what it means to be American since the end of the Civil War? Supporters of restricting birthright citizenship frame this as a long overdue correction. They argue that automatic citizenship for anyone born on U.S. soil encourages illegal immigration, incentivizes so-called birth tourism, and places unfair burdens on schools, hospitals, and local taxpayers. In their view, tightening the rules is about restoring fairness to those who follow the law, wait in line, and pursue visas and green cards through official channels. But the other side sees something much deeper and darker. For critics, this is not just an immigration tweak. It is an attempt to roll back a hard-won constitutional safeguard that was written after the Civil War precisely to prevent future governments from deciding which children deserve to belong. The 14th Amendment was a direct answer to an era when Black Americans were told they could never be citizens, no matter where they were born. To undermine that principle now, they argue, risks reopening a door that history had tried to slam shut. Beyond the legal doctrines lies a very real human cost. Limiting birthright citizenship would not simply affect abstract categories on a policy memo. It would shape the lives of children who grow up speaking English, attending American schools, pledging allegiance to the flag, yet discovering that on paper, they are not fully part of the nation they call home. That is how a shadow population forms. People who live in the United States but exist in permanent limbo, with fragile legal status and limited rights. Few things are more dangerous for a democracy than creating a group that is here but never fully allowed to belong. There is also a practical problem that rarely makes headlines. If citizenship depends on the legal status of parents at the moment of birth, who carries the burden of proof? Hospital staff? Local officials? Federal agencies already overwhelmed with paperwork? Every birth becomes a potential legal case. Every missing document becomes a source of uncertainty. The result could be years of litigation, inconsistent rulings across states, and families trapped in an endless maze of bureaucracy. Ordinary Americans are watching this battle through very different lenses. Some see overloaded schools, strained local budgets, and a border that feels out of control, and they welcome any measure that promises order, even if it comes at a constitutional cost. Others see their neighbors, co-workers, and classmates whose families arrived with little more than a suitcase, and they fear that stripping away birthright citizenship sends a message that those families will never truly belong. For many in immigrant communities, this fight is not an abstract argument on cable news. It is a question about whether their children will be treated as full members of the only country they have ever known. Layered on top of all this is the question of social cohesion. Democracies depend on a shared sense of we, a belief that, despite disagreements, people are part of the same political community. Policies that divide residents into full citizens and permanent outsiders risk fraying that sense of common purpose. When the line between us and them is drawn not just at the border but in maternity wards, classrooms, and neighborhoods, the very fabric of national unity can start to tear. The debate over birthright citizenship is therefore also a debate over whether the United States sees inclusion as a strength or as a threat. In a century defined by demographic change and global competition, that choice may prove as consequential as any court ruling. And then there is the international dimension. For generations, the United States has projected an image, sometimes more idealized than real, of a country where anyone who is born there can grow up to claim the full rights of citizenship. That promise has been part of America's soft power, its moral branding in a crowded world. If Washington steps back from that principle, allies and rivals alike will be watching. Does the U.S. still see itself as a land of opportunity, or is it turning inward into a more closed, fortress-like model? Ultimately, this case forces the Supreme Court to confront its own role as guardian of the constitutional order. Will the justices treat birthright citizenship as a settled pillar of the post-Civil War settlement, or as a flexible policy choice that can be narrowed by the executive branch? Whatever they decide, the ruling will echo far beyond the courtroom. It will shape how millions of people, citizens and non-citizens alike, understand what the words "equal protection of the laws" actually mean. So as the nation waits for the court's answer, one question belongs not just to judges and politicians, but to all of us. Should birthright citizenship remain a non-negotiable promise at the heart of the American story? Or is it time for the United States to fundamentally rewrite who gets to be called American in the decades ahead?